Welcome everyone to our advanced English discussion on crime and justice. Priya, have you seen the latest headlines about the Simmons case? It sparked quite a debate on how justice is handled.
Absolutely, James. The Simmons trial has gripped the nation. The evidence, the media coverage, and the public's response all make it a perfect example to dissect how legal systems function under pressure.
It's an excellent case for exploring not just facts, but the reasoning behind legal decisions. Let's dive into the investigation process first, shall we?
Great idea. Examining how the crime was investigated helps us understand the foundation of any trial. Without a solid investigation, even the best legal arguments can fall apart.
In the Simmons case, the police collected forensic evidence and interviewed dozens of witnesses. Priya, from your perspective as a journalist, what are the main obstacles investigators face in such high-stakes cases?
One major challenge is maintaining objectivity. Investigators must avoid confirmation bias, tendency to focus on evidence that supports a theory. For instance, if they believe Simmons is guilty, they might overlook details that suggest otherwise.
That's a crucial point. In legal terms, failing to consider alternative scenarios can undermine the entire prosecution. It's similar to a scientist ignoring data that contradicts their hypothesis.
Exactly. And with social media amplifying rumors, investigators must sift through misinformation. A single misleading post could influence witness statements or even jury opinions.
Let's discuss the evidence presented in court. I noticed the case relied heavily on circumstantial evidence rather than direct proof. What's your take on that?
Circumstantial evidence, like being seen near the crime scene, can be persuasive but isn't definitive. As a journalist, I've seen convictions overturned when new direct evidence comes to light, like DNA analysis.
Indeed, the standard is beyond a reasonable doubt, but with only indirect clues, there's always room for uncertainty. That's where modals of deduction come in. We might say, he must have been there, but not, he was definitely there.
Right. And jurors need to distinguish between what could have happened and what must have happened. Misunderstanding this can lead to wrongful convictions.
Moving to the courtroom, could you explain how roles like prosecutor, defendant, and witness interact during a trial? Many listeners might not know the distinctions.
Certainly, the prosecutor presents the case against the defendant, aiming to prove guilt, while the defendant and their attorney work to refute the charges. Witnesses provide testimony, which can support either side.
And the judge ensures the trial remains fair, ruling on objections and guiding the jury. In some countries, like India, judges even decide the verdict, whereas in the UK and US, that's the jury's job.
That's a key difference. The way these roles interact influences not only the outcome, but also the perceived fairness of the entire process.
This leads us to how legal professionals use language to express certainty or doubt. In the Simmons trial, lawyers repeatedly said things like, he must have planned this, or he might be innocent.
Exactly. Modals of deduction such as must have, might have, or couldn't have allow for nuanced interpretations. This is crucial when the facts aren't crystal clear.
For example, if no one saw the defendant at the scene, we'd say, he couldn't have been there. But if his fingerprints were found, he must have touched the object.
It's a delicate balance. Overstating certainty can mislead a jury, while hedging too much may undermine a valid argument. The right modal helps communicate the exact degree of confidence.
Let's compare how justice is served in different countries. As a law student in the UK, I'm used to the common law system, where precedent and jury trials are central. Priya, how does India's system differ?
India uses a hybrid system. While we inherited many common law traditions from the British, our judges often play a more active role. For example, judges can question witnesses directly, which is rare in the UK.
That's fascinating. In civil law countries like France, the process differs even more. The judge conducts the investigation and leads the trial. Each system shapes how justice is perceived and delivered.
Absolutely. It's important for learners to see that what's considered fair or just can vary widely based on legal tradition and cultural context.
Fairness is central to any justice system. However, studies show that bias, whether racial, socioeconomic, or gender-based, can influence outcomes. How do you see this playing out in high-profile cases?
Bias is a real problem. For example, a 2022 study found that defendants from marginalized backgrounds in the U.S. are 30% more likely to receive harsher sentences for similar crimes. The media often amplifies stereotypes, affecting public opinion and even jury decisions.
That's troubling. Efforts like blind review of evidence or diversity training for judges aim to minimize bias, but there's still a long way to go. Could you share an example from your reporting?
In a recent corruption trial, the defendant's social status seemed to shield him from scrutiny, while a co-accused from a poorer background was vilified. It's a stark reminder that justice isn't always blind.
Let's move to sentencing. There's a growing debate over whether justice should focus on punishment or rehabilitation. What trends have you noticed in India?
Historically, our system was punitive, but there's increasing emphasis on rehabilitation, especially for non-violent crimes. Programs offering education or job training have reduced reoffending rates by up to 20%.
That mirrors shifts in the UK, where restorative justice initiatives aim to repair harm and reintegrate offenders. Some critics argue, however, that lenient sentences may undermine deterrence.
It's a delicate balance. The challenge is to protect society without perpetuating cycles of crime. A 2021 UN report found that countries emphasizing rehabilitation saw lower long-term crime rates.
Even after a verdict, the search for justice continues. Appeals allow for review of possible errors or new evidence. How effective is this process in practice?
Appeals are vital, but access can depend on resources. In India, backlog means some appeals take years. Still, they provide a crucial safeguard-owned study showed that 15% of criminal convictions are overturned on appeal in the UK.
That's significant. Appeals also highlight the system's commitment to correcting mistakes, but delays can mean justice is postponed. How do you think this impacts public trust?
Lengthy delays can erode confidence, especially for victims, but seeing wrongs righted even years later reinforces the principle that justice is a process, not just a verdict.
Let's wrap up by considering public reaction and the media's role. High-profile cases like Simmons often play out in both courtrooms and headlines. How does media coverage shape perceptions of justice?
Media can inform but also mislead. Sensational reporting may sway public opinion before all facts are known. For example, studies show that 40% of jurors admit to being influenced by pre-trial publicity.
That's striking. Responsible journalism and media literacy are essential for ensuring that justice is based on evidence, not emotion. Any final thoughts for our listeners, Priya?
I'd encourage everyone to think critically, question assumptions, and always seek out multiple perspectives. Justice isn't always black and white. It's a complex, evolving conversation.